Hi, I'm Dr. Chan, and welcome to another CME video. Please watch the video till the end, and we'll provide details on how to get CME points. Thank you for watching.
Hello, good evening everyone. My name is Fazliza binti Azli. I'm from Mr. Chan Banting and Company, or it's known as CBE. Today, my presentation would be on this topic, an insight into medical disciplinary proceedings in Malaysia. Obviously, first of all, there must be a complaint lodged by the complainant or by the information against the registered medical practitioner. Upon receipt of a complaint against a registered medical practitioner, or is known as RMP, an investigation will commence when the Preliminary Investigation Committee, or is known as PIC, convenes on a date set for investigation of the state complaint. Once the PIC decided to proceed with the investigation, the PIC bears the primary responsibility and authority to find out whether there are sufficient grounds to support the allegation of facts and issue. In this regard, the PIC shall notify the registered medical practitioner within 30 days upon receipt of the complaint and require the registered medical practitioner to submit a reply within 30 days of receipt of such notification from the PIC. And if necessary, request for clarification or further documentation from the registered medical practitioner to be provided within 14 days of a request by the PIC. On this further documentation, usually we'll be referring to the medical record or the medical report pertaining to the patient, or if at all, it would be an expert report in order to support in terms of the care management of the registered medical practitioner, whether it's acceptable or otherwise. And in the event that the complainant is not traceable, and after looking through the complaint lodged by the complainant and the facts do not constitute a disciplinary matter, or at the very least, the PIC has reason to doubt the truth of the complaint or information, the complaint therefore would be dismissed summarily. And upon considering the registered medical practitioner reply and further clarification, and if the Preliminary Investigation Committee feels that there's a basis to the complaint, PIC may then recommend to the council may recommend to the council for an inquiry to be held by a disciplinary board to decide further on the particular matter. All right. In the event that the disciplinary board decided to proceed further with the investigation, at the outset, an interim order can be given by the disciplinary committee with a view to protect the members of the public or for public interest. The types of interim order that can be given is on, basically there are two. One is on the interim suspension order, and the other one is on the interim restricted registration order. For the interim suspension order, basically it is a suspension of the registered medical practitioner registration for a period not exceeding 12 months. That is called interim suspension order. Whereas for the interim restricted registration order, merely it means that the medical practitioner can continue with the practice, but subject to compliance with requirement or restriction imposed by the disciplinary board, which they may think fit in order to avoid further complication or issues arising, from his practice. And this will take place for a period not exceeding 12 months as well. Once interim orders being given, it would be reviewed for every 6 months from the date of the order. And the subsequent review would be before the end of 3 months from the previous review, as long as the order continues in force or when new evidence becomes available to the DB. As I mentioned earlier, the interim order shall not exceed the period of 12 months. And for the extension, it is actually up to the president of the medical council to grant some extension for 6 months, and each time extension is sought by the DB. Prior to the proceedings, the disciplinary board shall be writing to the complainant requiring his attendance and his witnesses before the DB at a specified time, date, and place. DB shall also write to the registered medical practitioner informing of the same, i.e. on the time, date, and place, to enable the registered medical practitioner to be present with or without legal counsel. Both complainant and the registered medical practitioner have the right to be present with or without legal counsel with equal rights of representation. And before the commencement of the hearing before the disciplinary board, this documentation will be provided. First, the complainant or informant's letter. Secondly, the respondent's reply and clarification. Thirdly, on all other documents which is relevant pertaining to the complaint. The disciplinary board, if at all, shall complete the inquiry within 6 months of its date of appointment, unless an extension being granted by the council. During the proceeding of the inquiry, the disciplinary board chairman will introduce the members of the DB, his legal advisor and secretariat, the complainant, the registered medical practitioner, and those present with him will be asked to identify themselves. Then the disciplinary board chairman will ensure that all relevant documentation and laws to be referred to are in order and shall explain the inquiry procedures, responsibility, and authority of the disciplinary board. A certified interpreter or translator may be made available during the proceedings, and the complaint shall first present their complaint before the disciplinary board. So with this, basically, it is called as examination of complainant, where the complainant would present their complaint before the board, and the disciplinary board would inquire further from the complainant of relevant information. So once that is done, if the registered medical practitioner or the respondent is represented by a solicitor, therefore the registered medical, the doctor's lawyer basically would be doing the cross-examination, meaning to ask further questions to complainant and to obtain relevant information, basically to show that there's no basis to the complaint. And once that is done, the disciplinary board would re-examine the complainant if necessary. Once we are done with the complainant, then the next step would be the same process where the examination by the disciplinary board for the witnesses produced in order to support the complainant's complaint. It follows by the cross-examination by the doctor's lawyer, cross-examination on the witnesses, and subsequently the re-examination by the disciplinary board if necessary. Once we are done with the examination, i.e. asking questions to the complainant and also to their witnesses, therefore parties, the complainant and also the doctor, they must submit before the disciplinary proceeding, the disciplinary board, as to why the complaint should be maintained and as to why the complaint should be dismissed if at all. In the event that the disciplinary board decided to is of the view that there's a basis to the complaint, the DB would decide to decide for the doctor to submit their defense before the disciplinary board. Or in the event that there's no basis to the complainant, then of course the disciplinary board would recommend to the council that no further action to be taken. As I mentioned earlier, in the event that the disciplinary board decided to frame charges against the respondent, DB will issue a call letter to the respondent or to the doctor indicating the date, time and place of the inquiry. And at the end of the day, yes, the registered medical practitioner has the right to produce any witnesses or documentary evidence to support his defense. And of course, the doctor do have their right to legal counsel as well. Once charge being framed, it would be in respect of the circumstances surrounding the case in specific, clear, precise, and accurate terms, and the offence allegedly committed in specific, clear, precise, and accurate terms. If, for whatever reason, the doctor decided not to put forward any defense or to call any witnesses in support, it is always up to the disciplinary board jurisdiction to proceed further with the matter and to recommend to the medical counsel, that the registered medical practitioner is guilty of the charges framed against him. So at the defense stage, it would be the same procedure as the complainant stage, where the DB shall be recording the statement from the respondent, i.e. the doctor. The respondent doctor may be required to produce any relevant materials before the DB. Basically, for this, we'll be referring to the medical report, the medical record, or the expert report, or at times literature, which may support the defense of the doctor. Once that is done, the disciplinary board will start to question the doctor in terms of the facts of the matter, the conduct, and subsequently the complainant would be putting across his questions to the doctor, and the disciplinary board would be doing the re-examination if necessary. The same goes for the respondent's witnesses, the same procedure. On the postponement, it is only up to maximum of 2 postponement will be allowed with a valid reason. And in the event that the witnesses were to be absent, only a maximum of 3 chances will be given to both parties to appear before the DB. And if the complainant fails to appear for whatever reason, the disciplinary board may